This will be a special meeting of the Eureka Springs City Council. The item on the agenda tonight is the 2007 water and sewer bonds refunding issue. Madam Clerk, would you establish a quorum, please?
Parker Raphael.
Here.
James DeVito.
Here.
Karen Lindblad.
Here.
Butch Berry.
Present.
Laney Balance.
Here.
Ken Pownall.
Ladies and gentlemen, again, it's our pleasure to have Michael Moyers with the Friday Law Firm and Dennis Hunt with Stevens. We can do this, let them talk first, or you can open this for discussion, talk amongst the table, and then let them talk. Whatever y'all's preference is. So, motion to discuss.
So moved.
Second.
Made and seconded. Floor is open. Yes, sir.
I think it might be good to have them give a brief overview of, because we do have a new member of the council with us tonight.
Okay. Dennis, you want to come on up here?
Mayor Pate, members of the council, I'm Dennis Hunt with Stevens, and with me this evening is Michael Moyers with the Friday Law Firm. Subsequent to you approving the resolution authorizing us to proceed with attempting to realize a savings for the city on refunding your 2007 sales and use tax bonds, a variety of documents were prepared. A lot of information was gathered in terms of your sales tax collections, in terms of activities going on in the city. And that document, then known as an official statement, was presented to investors about a week to 10 days ago. And those in the investment community then reviewed those documents. And then yesterday morning at 9 a.m., we priced and offered your refunding bonds to the market. The market received the bonds very, very favorably. We were able to even reduce the interest rates on some of the maturities because we had more orders than there were bonds available. The interest rate that the city was able to achieve and what we committed to underwrite is 2.82%. That compares to your outstanding bonds, your 2007 bonds that had an interest rate of 4.59%. As a result of that reduction in the interest rate, there's a net savings to the city of about $348,610. That compares favorably to the information that we provided to you previously when you first initiated this refunding process. I was very pleased with the manner in which the bonds were sold. We have about $230,000 that remain unsold, but we are committing to buy those bonds and we'll hope to remarket those bonds at a future date. I'll be happy to address any questions that you may have.
Any questions from the council?
I don't have a question. I do have a comment. This gross debt tax, this gross debt tax comparison you provided to us was very helpful.
Thank you very much.
Anybody else?
And if there are specific questions with respect to the ordinance, Michael Moyers is the one that drafted that document, and I'm sure he'll be happy to address any questions you may have.
Thank you, sir. Michael, come on.
Good afternoon, everyone. I'm Michael Moyers with the Friday Law Firm. I prepared the ordinance that you have before you tonight. And as far as moving forward with the bonds, the next thing that needs to occur is this ordinance needs to be adopted tonight. If it is adopted tonight, it'll authorize the mayor to sign the contract with Stevens to sell the bonds, and it'll authorize us to move forward. Right now, we project that we will call the old bonds on October the 1st of this year, which is the first date when that can occur. And at the closing, money will be put into an escrow fund that will sit in that fund and then call the bonds on that day. These bonds are pledged and payable from the 1% sales tax that was levied in 1990, and it will continue to be paid from that tax. From the city's perspective, the only difference that you will see from this transaction and your transaction back in 2007 is at the end of the day, on a monthly basis, more money will come back to the city after debt service on the bonds are paid. Yes, sir.
Is there an emergency clause on this ordinance?
Yes, sir, there is.
There is? Okay.
Any further? Mr. Berry?
Mr. Moore, when will the city start realizing the return?
Dennis, the closing is scheduled for the,
July the 11th, and if
Yeah.
you'll look at that sheet that I provided as an attachment to my letter, you can see on October 1 of 2012, you'll actually get $57,275 more back from the state than you would have if you had not refunded those bonds. And then it's showing you a full year. Actually, the payments, interest payments are made every 6 months, and so you kind of divide those by 2, and it'll show you then, and every 6 months after October 1 of 2012, you'll get half of the $217,132. So you'll be receiving, you'll notice a significant improvement almost instantaneously when those bonds close, because each month the state is going to have more money, or the trustee is going to have more money to send back to you in order to, and still be able to fulfill the debt obligation.
Any further?
and at the council's pleasure, I can either read the ordinance in its entirety, or if you elect to suspend the rules on all 3 readings and read by title only, I'm fine with that approach also.
Yes, ma'am.
I believe it needs to be read into the public record.
Mr. Barry?
I'm
sorry,
Could I
Mr.
ask the
DeVito.
city attorney's opinion on that? It is a lengthy document.
It is at your direction how you want to do it. If the bond counsel and people doing the bonding are okay with it, will not violate any rules to do it by title only. But in the past, I think it's been done both ways at this table. It just depends on the council decision.
And from my perspective, I'm happy to, it's at the council's pleasure.
Mr. Barry, Mr. DeVito again?
I would move to suspend the rules, assign this ordinance a number, place it on its first reading by title only.
Ms. Clerk?
My signature is going on this document. I would prefer that it be read into the public record. I am not interested in signing something that hasn't been made very clear.
We got a motion on the table, need a second. Barry, Mr. DeVito?
I would move to assign this ordinance a number and place it on its first reading.
Second.
Made and seconded. This need to be a roll call, since this is a new ordinance.
Not at this point. It doesn't have to be.
All in favor, say aye.
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 Any opposed? Motion carried. Is this for discussion? Only on the first reading? Okay, so you're going to go ahead and do this, okay?
Okay?
We need a number for it.
The ordinance number will be 2153.
Okay, an ordinance authorizing the issuance of sales and use tax refunding bonds for the purpose of refinancing the cost of capital improvements, pledging 1% sales and use tax to pay the principal of and interest on the bonds, procuring other matters relating thereto, and declaring an emergency. Whereas the City of Eureka Springs, Arkansas, has previously issued under Amendment number 62 to the Constitution of the State of Arkansas, in Title 14, Chapter 164, Subchapter 3 of the Arkansas Code of 1987, mandated the sales and use tax refunding improvement bond series 2007 for the purpose of financing and refinancing the cost of capital improvements. Whereas the City Council has determined the City to be able to achieve debt service savings by refunding the Series 2007 bonds, and whereas the City can obtain necessary funds for the refunding of the Series 2007 bonds with the issuance of sales and use tax refunding bond Series 2012 in an aggregate principal amount of $3,375,000, and by appropriating available funds held for the Series 2007 bonds, whereas the City has made arrangements to sell the Series 2007 bonds to Stephen Inc. at a purchase price of $3,341,893.80, principal amount plus original issue premium $17,518.80, plus underwriter's discount of $50,625, plus accrued interest. Proceeding to a bond purchase agreement between the purchaser and the city, which has been proceeded to and is before this meeting, whereas a preliminary official statement dated May 17, 2012, offering the Series 2012 bonds for sale has been presented to and is before this meeting, whereas a continued disclosure agreement between the city and the Bancorp South Bank, Stuttgart, Arkansas, providing for the disclosure obligation of the city with respect to the Series 2012 bonds has been presented to and is before this meeting. Now therefore be it ordained by the City Council of the City of Eureka Springs, Arkansas. Section 1, the refunding shall be accomplished. The mayor and the city clerk are hereby authorized to take all action necessary in connection therewith and to execute all required contracts and documents. Series 2007 bonds shall be called for redemption on October 1, 2012, or the earliest practical date thereafter, the redemption price equal to the principal amount outstanding plus accrued interest. Section 2, the offer of the purchaser for the purchase of the Series 2012 bonds from the city at the purchase price for the Series 2012 bonds bearing interest at the rates per annum, maturing and otherwise subject to the terms and provisions there hereafter in this ordinance set forth in detail B, and is hereby accepted in the agreement substantially the form submitted to this meeting is approved and confirmed that the Series 2012 bonds are hereby sold to the purchaser. The mayor is hereby authorized and directed to execute and deliver the agreement on behalf of the city and take all action required on the part of the city to fulfill its obligations under the agreement. Section 3, the preliminary official statement is hereby approved and the use of the previous use of the preliminary official statement by the purchaser in connection with the sale of Series 2012 bonds is hereby in all respects approved and confirmed, and the mayor being hereby is authorized and directed for and on behalf of the city to execute the preliminary official statement and the final official statement in the name of the city to be delivered to the purchaser for its use in connection with the sale of Series 2012 bonds as set forth in the agreement. Section 4. Under the authority of the constitutional laws of the state, including particularly Amendment Number 62 to the Constitution of the state and Title 14, Chapter 164, Subchapter 3 of the Arkansas Code in 1987, annotated City of Eureka Springs, Arkansas, sets and use tax refunding bond, Series 2012, hereby authorized and ordered issued in the total principal amount of $3,375,000. Proceeds from the sale of which are necessary along with available funds to accomplish the refunding, pay expenses as applicable thereto, provided that service reserved, and pay expenses of issuing Series 2012 bonds. Series 2012 bonds and any additional parity bonds issued under Section 11 hereof are herein referred to as collectively as the bonds. Series 2012 bonds shall bear interest at the rates and shall mature on October 1 and the amounts and then the years as follows. This is the maturity schedule showing the interest rates per year ranging from 1% to 3.55%. That's what that chart is. Series 2012 bonds shall be issued only as fully registered bonds without coupons and denomination of $5,000 or any integral multiple thereof, unless the city shall otherwise direct. Series 2012 bonds should be numbered from 1 upwards in order of issuance. Each Series 2012 bond shall have a CUSIP number, but the failure of a CUSIP number to appear on any Series 2012 bond shall not affect its validity. Series 2012 bonds should be registered initially in the name of Seed & Co. as the nominee for the Depository Trust Company, which should be considered to be registered owner of Series 2012 bonds for all purposes under this ordinance, including without limitation payment by the city the principal of redemption price, premium, if any, and interest on Series 2012 bonds, and the receiving notices and exercise of rights of registered owners. There shall be one certified typewritten Series 2012 bond for each stated maturity date that shall be immobilized in the custody of DTC, with the beneficial owners having no right to receive the Series 2012 bonds in the form of physical securities or certificates. DTC and its participants shall be responsible for maintenance of records of the ownership of beneficial interests in the Series 2012 bonds by book entry on the system maintained and operated by DTC and its participants, and transfers of ownership of beneficial interests shall be made only by DTC and its participants by book entry, the city having no responsibility therefore. DTC is expected to maintain records of the positions of participants in Series 2012 bonds, and the participants and persons acting through the participants are expected to maintain records of the purchasers of beneficial interest in Series 2012 bonds. Series 2012 bonds, as such, shall not be transferable or exchangeable except for transfer to other security depository and to another nominee of the security depository without further action by the city. If any securities depository determines not to continue to act as a security depository for the Series 2012 bonds for use in a book entry system, the city may establish a securities depository book entry relationship with another securities depository. The city does not or is unable to do so, or upon the request of the beneficial owners of all outstanding Series 2012 bonds, the city and the trustee, hereinafter identified, after the trustee has made provision, for the notification of the beneficial owners by the then securities depository, shall permit withdrawal of Series 2012 bonds from the security depository and authenticate and deliver the bond certificates in a fully registered form and denominations of $5,000 or integral multiples thereof to the assigned at the securities depository for its nominee all at the cost and expense, including cost of printing and defending the bonds of the city, if the city fails to maintain a security depository bunk entry system, or the beneficial owners of they request termination of the system. Prior to the issuance of Series 2012 bonds, the city shall have executed and delivered to DTC a written agreement setting forth or incorporating therein by reference certain undertakings and responsibilities of the city with respect to the Series 2012 bonds, so long as the Series 2012 bonds or a portion thereof are registered in the name of Stephen Co. or a substitute nominee and held by DTC. Notwithstanding such execution and delivery of the representation letter, the terms thereof shall not in any way limit the provisions of this section or in any other way impose upon the city any obligation whatsoever with respect to the persons having interest in the Series 2012 bonds other than the registered owners as shown in the registration books kept by the trustee. Trustees shall take all action necessary for all representations of the city in the representation letter with respect to the trustee to at all times be complied with. Authorized officers of the trustee in the city shall do or perform such acts and execute all such certificates, documents, and other instruments as they or any of them deem necessary or advisable to facilitate the efficient use of the security depository for all or any portion of the Series 2012 bonds, provided that neither the trustee nor the city may assume any obligations to such security depository or beneficial owners of the Series 2012 bonds that are inconsistent with their obligations to any registered owner under this ordinance. Each Series 2012 bond shall be dated July 1, 2012. Interest on the Series 2012 bond shall be payable on October 1, 2012, semi-annually thereafter on April 1 and October 1 of each year. Payment of such installment of interest shall be made to the person in whose name the Series 2012 bonds is registered on the registration books of the city maintained by Bancorp South Bank, Stuttgart, Arkansas, as trustee and paying agent at the close of business on the 15th day of the month, whether or not a business day next preceding each interest payment date, irrespective of any transfer or exchange of any such Series 2012 bonds subsequent to such record date and prior to such interest payment date by check or draft mailed to the trustee to such owner at his address on any registration books. Principal of the Series 2012 bond shall be payable to the corporate trust office of the trustee. Each Series 2012 bond shall bear interest from the payment date next preceding the date on which it is authenticated unless it is authenticated on the initial payment date, in which event it shall bear interest from such date or until it is unless it is authenticated prior to the first interest payment date, in which event it shall bear interest from July 1, 2012, or unless it is authenticated during the period from the record date to the next interest payment date, in which case it shall bear interest from such interest payment date, or unless at the time of authentication thereof interest is in default thereon, in which event it shall bear interest in the date to which interest has been paid. On which such Series 2012 bonds have endorsed thereon with certificate of authentication substantially in the form set forth in Section 6 hereof, duly executed by the trustee, shall be entitled to any right of benefit under this ordinance. No Series 2012 bond shall be valid and obligatory for any purpose unless and until the certificate shall have been duly executed by the trustee, and the certificate of the trustee upon any such Series 2012 bond shall be conclusive evidence that such Series 2012 bond has been authenticated and delivered under this ordinance. The certificate should be deemed to have been executed and signed by an authorized officer of the trustee, but it should not be necessary that the same officer sign the certificate on all the Series 2012 bonds. In case any Series 2012 bond shall become mutilated or destroyed or lost, the city shall, not then prohibited by law, cause to be executed, and the trustee may authenticate and deliver a new Series 2012 bonds of like date, number, maturity, and tenor in exchange for substitution for upon cancellation of such mutilated Series 2012 bonds, or in lieu of and a substitution for such Series 2012 bond destroyed or lost upon the owner paying the reasonable expenses charged to the city and trustee in connection therewith, and in the case of Series 2012 bond destroyed or lost, his filing with the trustee evidence satisfactory to such Series 2012 bond was destroyed or lost, and of his ownership thereof, and furnishing the city and trustee with indemnity satisfactory to them. Trustee is hereby authorized to authenticate any such new Series 2012 bond, and any such Series 2012 bond shall mature. Instead of issuing a new Series 2012 bond, the city may pay the same without surrender thereof. Upon the issuance of a new Series 2012 bond under this section, the city may require the payment of a sum sufficient to cover any tax or other governmental charge that may be imposed in relation thereof, and any other expense, including the fees and expenses of the trustee connected therewith. The city shall cause books to be maintained for the registration and for the transfer of the Series 2012 bonds provided herein, and the Series 2012 bonds. The trustee shall act as the bond registrar. Each Series 2012 bond is transferable by the registered owner thereof or by its attorney duly authorized in writing at the principal office of the trustee. Upon such transfer into new fully registered 2012 bond or bonds at the same maturity of authorized denomination or denominations, the same aggregate principal amount shall be issued to the transferee in exchange thereof. Series 2012 bonds may be exchanged to the principal corporate trust office of the trustee for an equal aggregate principal amount of Series 2012 bonds or of any other authorized denomination or denominations. The city shall execute and the trustee shall authenticate and deliver Series 2012 bonds for the registered owner, making the exchange entitled to receive the execution by the city of any Series 2012 bonds or any denomination shall constitute full and due authorization of such a denomination, and the trustee shall therefore thereby be authorized to authenticate and deliver such Series 2012 bond. No but charge shall be made to any owner of any bond for the privilege to transfer up or exchange, but any owner of any bond requesting such transfer or exchange shall pay any tax or other governmental charge required to be paid with respect thereto, except as otherwise provided in the immediately preceding paragraph. The cost of preparing each new bond upon exchange or transfer and any other expenses of the city or the trustee incurred in connection therewith shall be paid by the city. Neither the trustee nor the city shall be required to transfer or exchange any bond selected for redemption in whole or in part. The person in whose name any bond shall be registered shall be deemed and regarded as absolute owner thereof for all purposes. The payment of or on account for the principal or interest on any bond shall be made only to who or upon the order of the registered owner thereof or his legal representative. Such registration may be changed as hereinabove provided. All such payments shall be valid and effectual to satisfy and discharge the liability upon such bond to the extent the sum or sums so paid. In any case where the date of maturity of interest on or principal of the bonds or date fixed or redemption of any of the bonds shall be a Saturday or Sunday or shall be in state a legal holiday or a date on which the banking institutions are authorized by law to close, then the payment of interest or principal need not be made on such a date but may be made on the next succeeding business day with the same force and effect as made on the date of maturity or the date fixed for redemption, and no interest shall accrue for the period after the date of maturity or the date fixed for redemption. Section 5, bonds shall be executed on behalf of the city, but the manual for assembly signatures of the mayor and city clerk shall have impressed or imprinted thereon the seal of the city. Section 6, Series 2012 bonds and the certificate shall be in substantially the following form, and the mayor and the city clerk are hereby expressly authorized and directed to make all recitals contained therein. After this, it's the form of the actual bond certificate, and it's not something that I would generally read if you want me to skip over it, but I'd be happy to read it if you want me to. It contains, other than one paragraph, which I will read, it just recites information that's in the ordinance in other locations. Okay, section I will read is on page 8 of the black line, third paragraph. These are the redemption features of the bonds. Bonds are subject to redemption at the option of the city from funds from any source on and after October 1, 2007, whole at any time or in part on any interest payment date. The redemption price equal to the principal amount being redeemed plus accrued interest at the redemption date. Fewer than all the bonds shall be called for redemption. Particular maturity shall be redeemed, shall be selected by the city in its discretion. Fewer than all the bonds of any one maturity shall be called for redemption. Particular bonds, a portion thereof, to be redeemed from such maturity, shall be selected by lot by the trustee. Okay, skipping over to, all right, done with the form of the bonds. Now we're section 7 at the top of page 11. Section 7. City hereby expressly pledges and appropriates all the revenues derived by the city from 1% sales and use tax levied by the city under the authority of the laws of the state and ordinance number 1386 of the city duly adopted on March 20th, 1990, to the payment of the principal of and interest on the bonds when due at maturity or redemption prior to maturity, to the payment of the fees and expenses of the trustee and other administrative charges, to the payment of any arbitrage rebate to the United States under Section 148F of the Internal Revenue Code of 1986 as amended, and to the maintenance of a debt service reserve. City covenants that the tax shall never be repealed or reduced while any of the bonds are outstanding. The city further covenants to use due diligence in collecting the tax. Nothing herein shall prohibit the city from increasing the tax from time to time to the extent permitted by law, and no part of the revenues derived from any such increase shall be part of the revenues pledged hereunder. Section 8. City hereby designates Bancorp South Bank, Stuttgart, Arkansas as the bank which shall receive collections of the tax from the state treasurer, and the city covenants to file a written designation thereof with the state treasurer prior to the issuance of Series 2012 bonds. Trustees shall deposit all pledged revenues as and when received into a special fund of the city, and the trustee, which is hereby created and designated Sales and Use Tax Revenue Fund, Series 2012. Monies in the revenue fund shall, within 2 business days of receipt, be applied each month in the following order of maturity or priority. 1. 1/6 of the interest on the bonds next due, debt service account of the bond fund. 2. 1/12 of the principal of the bonds next due, debt service account of the bond fund. 3. The trustee's fees and expenses and other administrative charges next due, expense account of the bond fund. 4. The amount which may be necessary to increase the debt service reserve at the required level, debt service reserve account of the bond fund. And 5, the amount necessary to pay any arbitrage rebate due under Section 148F of the Code, expense account of the bond fund. Balance shall be transferred to the city for use for lawful purposes within 2 business days of receipt of such monies. Deposits made in the debt service account of the bond fund shall be reduced in order to take into account as a credit: 1. Interest earnings; 2. Accrued interest deposited therein from bond proceeds; 3. Transfers from the debt service reserve account; and 4. Transfers from funds held in connection with the Series 2007 bonds. Monthly deposit shall be increased as necessary. There are sufficient funds to meet the first interest payment date and the first principal payment due on the bonds. Section 9, there is hereby created a special fund of the city and the trustee, which is designated Sales and Use Tax Bond Fund, Series 2012, for the purpose of providing funds for the payment of the principal of and interest on the bonds as they become due at maturity or at redemption prior to maturity. Any arbitrage rebate due to the United States under Section 148F of the Code, and the trustee's fees and expenses and other administrative charges. There shall be established in the bond fund the following accounts in which money shall be deposited: 1, debt service account; 2, expense account; and 3, debt service reserve account. Monies in the following bond fund account shall be used on each interest payment day in the following order of priority as and when necessary. 1, pay the interest on the bonds in due, debt service account; and 2, to pay the principal of the bonds in due, debt service account; and 3, to pay the trustee's fees and expenses and other administrative charges in due, expense account. In addition, monies in the expense account of the bond fund shall be used to pay when due any arbitrage rebate under Section 148 of the Code. Bond fund shall, except as provided in this section, be depleted once a year, except for a carryover amount not to exceed the greater of 1 year's earnings of the bond fund, or 2, 1/12 of the annual debt service of the bonds. Any monies in the bond fund shall, except as provided in this section, be spent on for one of the above purposes within a 13-month period, beginning on the date of deposit, and any amount received from investment of money held in the bond fund will be spent within a 1-year period, beginning on the date of receipt. Should be established and maintained in the bond fund debt service reserve account, the amount equal to 1/2 of the maximum annual debt service principal and interest requirements on the bonds. The city shall initially fund the debt service reserve for proceeds of Series 2012 bonds. Monies in the debt service reserve shall be used to make the payments described in clause 1 and 2 of A above. Monies in the debt service account of the bond fund are not otherwise sufficient for that purpose. Monies in the debt service reserve account and over and above the required level should be immediately transferred from the debt service reserve account to the debt service account of the bond fund, where the monies in the bond fund shall be and remain sufficient to pay: 1, principal of all the bonds then outstanding; 2, interest on the bonds until the next interest payment date; 3, the trustee fees and expenses and other administrative charges; and 4, all arbitrage rebate payments due in the United States under Section 148 of the Code. There shall be no obligation to make any further payments into the bond fund, and any pledged revenues remaining in the bond fund after the principal of premium, if any, and interest on the bond shall have been paid, may be used by the city for any lawful purpose. All monies in the bond fund shall be used solely for the purpose of paying the principal of and interest on the bonds. Any arbitrage rebate due under Section 148 of the Code, 148F of the Code, and the trustees' fees and expenses and other administrative charges at the same become due. Trustees authorized and directed to withdraw money from the bond fund from time to time as necessary for the pay of principal of and interest on the bonds when due, maturity, or redemption prior to maturity, and for making other authorized bond fund expenditures. Bonds shall be specifically secured by a pledge of the pledged revenues, which pledge in favor of the bonds is hereby hereof will be made according to the terms of this ordinance. And the city and the officers and employees of the city shall execute, perform, and carry out these terms thereof in strict conformity with the provisions of this ordinance. Section 10. Any bond shall be deemed to be paid within the meaning of this ordinance when payment of the principal of and interest on such bond, whether at maturity or upon redemption as provided herein or otherwise, either 1, shall have been made or caused to be made in accordance with the terms thereof, or 2, shall have been provided for by irrevocably depositing with the trustee and trust and irrevocably set aside exclusive for its purpose. 1, money sufficient to make any such payments, and or 2, government securities defined as Section 17 hereof, which are direct obligations to the United States of America, providing that such deposits shall not cause any of the bonds to be classified as arbitrage bonds within the meaning of Section 148 of the Code, maturing as principal and interest in such amounts and at such times to provide sufficient monies to make such payments, and all necessary and proper fees, compensation, and expenses of the trustee with respect to which such deposit is made shall have been paid, or the payment thereof provided for to the satisfaction of the trustee. On the payment of any bonds within the meaning of this ordinance, the trustee shall hold in trust for the benefit of the owners of such bonds all such monies and or government obligations. When all the bonds shall have been paid within the meaning of this ordinance, if the trustee has been paid his fees and expenses, a provision has been made therefore, and if all arbitrage rebate in the United States under Section 148F of the Code has been paid or provided for to the satisfaction of the trustees, the trustee should take all appropriate action to cause 1, the pledge and lien of this ordinance to be discharged and canceled; 2, all monies held by it pursuant to this ordinance which are not required for the payment of such bonds to be paid over or delivered to or at the direction of the city. Section 11. City covenants do not issue any additional bonds or incur any obligations secured by a lien on or pledge of the pledged revenues except authorized by this section. The city may issue bonds or incur obligations on the parity of security with the Series 2012 bonds under the provisions of this ordinance. The pledged revenues for the city 12 consecutive months or in excess of 125% of the average annual debt service requirements for the Series 2012 bonds or any outstanding additional parity bonds and the additional parity bonds proposed to be issued. The city may also issue additional bonds or incur obligations secured by a pledge if the pledge revenue is subordinate to the pledge in favor of the bonds. Section 12, the Series 2012 bonds shall be callable for payment prior to maturity in accordance with the terms set out in the face of the bond form set forth in Section 6 of this ordinance. Additional parity bonds may be subject to redemption prior to maturity in accordance with the terms set forth in the ordinance or ordinances authorizing their issuance. Section 13 is hereby covenanted and agreed by the city with the owners of the bonds that the city will faithfully and punctually perform all duties with reference to the tax of the bonds required by the Constitution and laws of the state of Arkansas and by this ordinance, including the collection of tax as herein specified and covenanted and applying of the pledge revenues as herein provided. Section 14, the trustee shall keep, cost to be kept, proper books, accounts, and records in which complete and correct entries shall be made with all transactions relating to pledge revenues, and such books shall be made available for inspection by the city, the purchaser, and the owners of any of the bonds at reasonable times and under reasonable circumstances. Trustee shall furnish a report to the city on a monthly basis of all receipts and disbursements of pledge revenues received by the trustee, which monthly report shall commence 1 month following the first month in which pledge revenues are received by the trustee. Section 15. If there be any default in the payment of the principal of and interest on any of the bonds, or if the city defaults in the performance of any covenant contained in this ordinance, trustee may and shall, upon the written request of the owners, not less than 10% principal amount of the bonds outstanding by proper suit, compel the performance of the duties of the officials of the city under the Constitution and laws of the state and under this ordinance, and take any action or obtain any proper relief in all or equity available under the Constitution and laws of the state. No owner of any bond shall have any right to institute any suit, action, mandamus, or other proceeding in equity or in law for the protection or enforcement of any right under this ordinance for the Constitution and laws of the state, unless such owner previously shall have given to the trustee written notice of default on account of which such suit, action, or proceeding is to be taken, unless the owners of not less than 10% of the principal amount of the bonds and outstanding shall have made written request to the trustee have the right to exercise such powers or right of action as the case may be, shall have been secured and shall have afforded the trustee a reasonable opportunity either to proceed to exercise the powers herein granted by the Constitution and laws of the state, or to institute such action. Suit or proceeding in its name, and unless also there have been offered to the trustee reasonable security and indemnity against the cost, expense, and liabilities to be incurred therein or thereby, and the trustee shall have refused or neglected to comply with such request within a reasonable time. Such notification, request, and offer of indemnity are hereby declared in every such case at the option of the trustee to be conditions precedent to the execution of the powers of the trust of this ordinance or to any other remedy hereunder. It is understood and intended that no one or more owners of the bond shall have any right in any matter whatsoever by his or their action to affect, disturb, or prejudice the security of this ordinance, or to enforce any right hereunder except in the matter herein provided, and that all proceedings of law or in equity shall be instituted, had, and maintained in the manner herein provided, and for the benefit of the owners of the outstanding bonds, and that any individual rights of action or right given to any one or more such owners by law are restricted by this ordinance to the rights and remedies herein provided. All rights of action under this ordinance or under any of the bonds enforceable by the trustee may be enforced by it without possession of any of the bonds, and any such suit, action, or proceeding instituted by the trustee shall be brought in his name and for the benefit of all owners of the bonds subject to the provision of this ordinance. No remedy herein conferred upon or reserved to the trustee or to the owners of the bonds intended to be exclusive of any other remedy or remedies herein provided, and then each and every such remedy shall be cumulative and shall be in addition to every other remedy given hereunder or given by any law or by the Constitution of the state. No delay or omission of the trustee or any of the owners of the bonds to exercise any right or power accrued upon any default shall impair any such right or power or shall be construed to be a waiver of any such default or an acquiescence thereof. And every power and remedy given by this ordinance to the trustee and to the owners of the bonds respectively may be exercised from time to time and as often as may be deemed expedient. Trustee may, and upon the written request of the owners, not less than the majority of the owners, the principal amount of the bonds and outstanding shall waive any default which shall have been remedied before the entry of final judgment or decree in any suit, action, or proceeding instituted under the provision of this ordinance, or before the completion of the enforcement of any other remedy. But no such waiver shall extend to or affect any other existing or any subsequent defaults or impair any rights or remedies consequent thereon. Section 16. When the Series 2012 bonds have been executed and sealed as herein provided, they shall be delivered to the trustee, which shall authenticate them and deliver them to the purchaser on payment of the purchase price. Accrued interest shall be deposited in the bond fund, the amount necessary for the purchase price to accomplish the refunding, along with the available money is appropriated by Section 22 hereof, as set forth in the delivery instructions, and the city trustee shall be deposited with the trustee for the owners of the Series 2007 bonds The amount necessary to fund the debt service surrender account to the required level should be deposited therein. The expenses of issuing Series 2012 bonds set forth in delivery instructions shall be paid from the purchase price. Balance of the purchase price of any shall be deposited into a special account in the name of the city designated cost of issuance fund and the trustee. Monies in the cost of issuance fund shall be dispersed solely in payment, cost of accomplishing the refunding, paying necessary expenses incidental thereto, paying expenses of issuance Series 2012 bonds. Disbursement shall be made by the trustee on the basis of requisition, which will contain at least the following information: the person with whom payment is being made, the amount of the payment, the purpose by general classification of the payment. Each requisition must be signed by the mayor. Trustees shall be required to keep accurate records as to all payments made from the cost of issuance fund. When all required expenses have been paid and the expenditures made from the cost of issuance fund for and in connection with the accomplishment of the refunding and the issuance of Series 2012 bonds, this fact shall, if there are any monies on hand for the cost of issuance fund, be evidenced by a certificate signed by the mayor, which certificate shall state, among other things, that all obligations payable from the cost of issuance fund have been discharged. A copy of the certificate shall be filed with the trustee, and upon receipt thereof, the trustee shall deposit any remaining balance from the debt service account in the bond fund. Notwithstanding the above, any monies remaining in the cost of issuance fund as September 1, 2012 shall be transferred into the debt service account in the bond fund. Section 17. Monies held with the credit of the revenue fund, the bond fund, and the debt service reserve account therein. The cost of issuance fund shall be invested and reinvested in one direct, fully guaranteed obligation to the United States of America, including any such securities issued or held in bookkeeping form with the books of the Department of Treasury of the United States of America. 2, direct obligations of any agency, instrumentality, or government-sponsored enterprise created by act of the United States Congress and authorized to issue securities or evidence of indebtedness, regardless of whether the securities or evidence of indebtedness are guaranteed for repayment by the United States government. Or 3, in time deposits, certificates deposited in the bank, including the trustee, which are insured by the Federal Deposit Insurance Corporation, or if in excess of insurance coverage collateralized by government securities or other securities authorized by state laws or public deposits, all of which shall mature or shall be subject to redemption by the holder thereof, the option of such holder not later than the date or dates which the money shall be required for payment of the principal of and interest on the bonds when due. Trustees shall invest and reinvest pursuant to the direction of the city and the trustee's discretion in the absence of any direct instructions from the city. Money held with the credit of the debt service reserve account of the bond fund shall be invested and reinvested in 1, government securities, 2, direct obligations of an agency, instrumentality, government-sponsored enterprise created by act of the United States Congress, and authorized to issue securities or evidence of indebtedness, regardless of whether the securities or evidence of indebtedness are guaranteed for repayment by the United States government. 3, in time deposits, certificates deposits to banks, including the trustee, which are insured by the FDIC or if the excess of insurance coverage or collateralized by government securities or other securities authorized by state law to secure public deposits, which shall mature, which shall be subject to redemption by the holder thereof, with the option of such holder not later than 7 years after the date of investment or the final maturity date of the outstanding bonds, whichever is earlier. Trustees shall so invest and reinvest pursuant to the direction of the city and the trustee's direct discretion in the absence of any direct instruction of the city. Obligations so purchased and investment of monies in any fund shall be deemed at all times to be part of such fund, and the interest accruing thereon and any profit realized from such investment shall be credited to such fund, and any loss resulting from such investment shall be charged to such fund. Money so invested in government securities or deposits banks to the extent insured by FDIC need not be secured by the trustee or by any deposit by the depository bank. All investments and deposits shall have par value or market value and less than par, exclusive of accrued interest at all times at least equal to the amount of money credited to such funds, and shall be made in such manner as the money required to be expended from any fund will be available to other at the proper time comes. Investment money in all funds shall be valued in terms of current market value as of the last day of each year, except the direct obligations in the United States, state and local government series. The bookkeeping form shall continuously value at par or pay its principal amount. Section 18. In the event that the office of mayor, city clerk, or city treasurer shall be abolished, or any 2 or more such offices shall be merged, consolidated, and in the event that the duties of a particular office shall be transferred to another office or offices, or in the event of a vacancy in any such office by reason of death, resignation, removal from office, or otherwise, or in the event any such officer shall become incapable of performing the duties of his or her office by reason of sickness, absence from the city, or otherwise, all powers conferred and obligations and duties upon such office or officer shall be performed by the office or officers exceeding the principal functions thereof, or by the office or officer upon whom such powers, obligations, and duties shall be imposed by law. Section 19, Bancorp Bank, Bank, Arkansas is hereby appointed the acting trustee patronage pursuant to this ordinance. Trustee shall be responsible for the exercise of good faith and reasonable prudence in the execution of this trust. Recitals in this ordinance and in the bonds are the recitals of the city, not of the trustee. Trustee shall not be required to take any action as trustee unless it shall have been requested to do so in writing by the owners and not less than 10% of the principal amount of the bonds and outstanding shall have been offered reasonable security and indemnity against the costs, expenses, and liabilities to be incurred therein or thereby. Trustee may resign by giving 60 days notice and writing to the city clerk and to the owners of the bonds the majority and principal amount of the owners of the outstanding bonds of the city, so long as it's not in default under this ordinance, at any time with or without cause may remove the trustee. In the event of a vacancy in the office of the trustee, the city shall appoint a new trustee. Such appointment be evidenced by written instrument or instruments filed with the city clerk. The new trustee shall be a bank or trust company duly authorized to exercise trust powers, and subject to examination by a federal or state authority, having reported capital surplus of not less than $10 million. Trustee and successor trustee shall file a written acceptance agreement to execute the trust imposed upon it by this ordinance, but only upon the terms and conditions set forth in this ordinance and subject to the provisions of this ordinance, to all of which the respective owners of the bonds agree. Such written acceptance shall be filed with the city clerk, and a copy thereof shall be placed in the bond transcript. Any successor trustee shall have all the powers herein granted to the original trustee. Trustee's resignation shall take effect upon the acceptance of the trust by the successor trustee. Section 20, terms of the ordinance constitute a contract between the city and the owners of the bonds, and no variation or change in the undertaking herein set forth shall be made while any of the bonds are outstanding, except as set forth in subsection B's, subsections B and C. Trustee may consent to any variation or change to the ordinance the trustee determines is not for material prejudice of the owners of the bonds in connection with the issuance of additional parity bonds or in order to cure any ambiguity, defect, or omission of this ordinance or any amendment hereto without the consent of the owners of outstanding bonds. Owners are not less than 75% aggregate principal amount of the bonds and outstanding shall have the right from time to time anything relating to this ordinance to the contrary notwithstanding to contest to and approve the adoption by the city of such ordinance supplemental hereto shall be necessary and desirable for the purpose of modifying, altering, amending, adding to, or rescinding any of the terms or provisions contained in this ordinance or in any supplemental ordinance, provided, however, that nothing contained in this section shall permit or be construed as permitting 1, an extension of the majority of maturity of the principal of or interest on any bond, or 2, reduction in the principal amount of any bond or the rates of interest thereon, 3, the creation of the pledge revenue superior to the pledge created by this ordinance, or 4, privilege or priority of any bond or bonds over any other bond or bonds, or 5, a reduction in the aggregate principal amount of the bonds required for consent to such supplemental ordinance. Section 21. Series 2012 bonds are hereby designated qualified tax-exempt obligations within the meaning of Section 265 of the Internal Revenue Code of 1986 as amended. The city represents the aggregate principal amount of its qualified tax-exempt obligations, excluding private activity bonds within the meaning of 141 of the Code, which are not qualified 501c3 bonds within the meaning of Section 145 of the Code, including those of subordinate entities issued during the calendar year 2012, not reasonably anticipated to exceed $2 million. City covenants will take no action which cause the Series 2012 bonds to be federally guaranteed within the meaning of Section 149B of the Code. The city further covenants will submit to the Secretary of the Treasury of the United States not later than the 15th day of the second calendar month after the close of its calendar quarter in which the Series 2012 bonds are issued. Statement concerning the Series 2012 bonds, which contains the information required by Section 149E of the Code. The city represents that it's not used or permitted the use of, and covenants are not used or permitted the use of the improvements to be refinanced by the Series 2012 bonds or the proceeds of the Series 2012 bonds in such manner as to cause the Series 2012 bonds to be private activity bonds within the meaning of Section 141 of the Code. In this regard, the city covenants that 1, it will not use directly or indirectly with the proceeds of the Series 2012 bonds to make or finance loans to any person, and 2, that while the Series 2012 bonds are outstanding, the improvements will be refinanced by the Series 2012 bonds will only be used by persons on the basis of members of the general public. The city shall pay any arbitrage rebate in the United States Treasury under Section 148 of the Code for monies in the bond fund. City covenants will not reimburse itself for Series 2012 proceeds for any costs paid prior to the set date of the Series 2012 bonds that are issued, except in compliance with the United States Treasury Regulation 1.150-2. Section 22, all monies in the bond fund, including the debt service reserve account therein held for the Series 2007 bonds, shall be used as necessary to accomplish the refunding Balance of any shall be deposited in the debt service account of the bond fund. Section 23, the mayor is hereby authorized and directed to work with Friday Elsham and Clark LLP, bond counsel, to develop and adopt and implement written procedures to monitor compliance with federal tax requirements with respect to tax-exempt obligations of the city. The mayor is further authorized to appoint a responsible person who will have primary responsibility for monitoring post-issuance tax compliance. Section 24, the disclosure agreement. Substantially, the form submitted to this meeting is approved. The mayor is hereby authorized and directed to execute the letter of disclosure agreement form on behalf of the city. The mayor is authorized and directed to take all action required on the part of the city to fulfill any city obligations under the disclosure agreement. Any legal fees and other administrative costs incurred by the city in connection with the disclosure agreement, except audit fees, shall be considered administrative costs payable from monies in the bond fund, hereinafter paid from the bond fund. Section 25, following adoption, this ordinance shall be posted in the following public places in the city: City Hall, Auditorium, Rick Springs Public Library, Harts Family Center, and Bunches Quick Check. Section 26, provisions of this ordinance is severable, and in the event any section or part thereof shall be held to be invalid, such invalidity shall not affect the remainder of this ordinance. Section 27, all ordinances and resolutions and parts thereof in conflict herewith are hereby repealed to the extent of such conflict. Section 28, hereby ascertained and declared that refunding must be accomplished as soon as possible in order to lower the interest costs or on obligations payable from the tax. Refunding cannot be accomplished without the issuance of Series 2012 bonds, and therefore it is declared that an emergency exists, and this ordinance, being necessary for the preservation of public peace, health, and safety, shall be enforced and take effect immediately upon and after its passage.
Thank you, sir. That was a mouthful. Mr. DeVito.
I move to approve ordinance number 2153 on its first reading.
Second.
Made and seconded. And we'll give a roll call. Yeah.
Mr. Berry.
Yes.
Ms. Balance.
Yes.
Ms. Lindblad. Yes. Mr. DeVito.
Yes.
Mr. Raphael.
Yes.
5-0.
Thank you. Yes, sir.
I move to suspend the rules and place ordinance number 2153 on its second reading by title only.
Second.
Made and seconded. You do voice vote on this.
Yeah.
All in favor, say aye.
No.
That's a roll call.
You need a roll call.
Another roll call? Okay.
Because they're suspending the rules.
Oh.
Ms. Lindblad. Yes. Ms. Balance.
Yes.
Mr. Raphael.
Yes.
Mr. DeVito.
Yes.
Mr. Berry.
Yes.
5-0.
Thank you.
It's an ordinance authorizing the issuance of sales and use tax refunding bonds for the purpose of refinancing the cost of capital improvements, pledging 1% sales and use tax to pay the principal of and interest on the bonds, describing other matters relating thereto, and declaring an emergency.
Mr. DeVito.
Move to approve ordinance number 2153 on its second reading.
Second.
All in favor, say aye.
Aye.
Any opposed? Mr. DeVito.
Move to suspend the rules and place ordinance number 2153 on its third reading by title only.
Second.
Second. Ms. Balance.
I have just a couple of little questions. When we look at page 6, we look at the first full paragraph. It says, except as otherwise provided in the immediately preceding sentence, the cost of preparing each new bond upon each exchange or transfer and any other expenses of the city or trustee incurred in connection therewith shall be paid by the city. Neither the trustee nor the city shall be required to transfer or exchange any bonds selected for redemption in whole or in part. So, except as otherwise provided in the minute. The cost of preparing each new bond upon each exchange or transfer and any other expenses of the city or the trustee incurred in connection therewith shall be paid by the city. I'd like an explanation of that, please.
Well, okay. This section, what it's talking about are replacement bonds. It is typical. This language is standard. The city will be paying the trustee's expenses throughout the process. So any expenses of the trustee would be passed on to the city. I've never seen this provision actually used, as far as replacing bonds goes. Right now, the cost of replacing bonds, because every individual investor used to would have gotten a $5,000 certificate for each $5,000 increment that it gets. Now we don't do that anymore. Any replacement bond would just be a slip of paper that I would print off of my printer.
Okay.
Any further? Is that on this, John?
No, it's not.
Okay.
So when we look at page 4, toward the end of the first paragraph there, it's talking about deliver bond certificates, fully registered form in denominations 5,000 or integral multiples thereof to the assigns of the securities deposits of or its nominee, all at the cost and expense, including costs of printing definitive bonds of the city, if the city fails to maintain it. Do we maintain a securities depository book entry system?
Yes, you've one of the cost of issuance of this bond issue is the city's fee to DTC, which is called the Depository Trust Company, and they are a book entry depository. So yes, you might not know it, but you do.
Okay. Let's see. Page 15, section F. Could you give me just a little explanation of what that means, please?
Page 15, so that's section 15, subparagraph F.
Yes, sir.
This is if the city defaults on any of the covenants that are in this ordinance or on the payment of the bonds, and the trustee institutes a lawsuit against the city. This says that the trustee, let me make sure, can waive the default if you bring yourself into compliance. If you pay the amount owed before the final judgment is rendered against the city, the trustee can cancel its action.
Okay. Page 16, section 17, the last sentence. The trustee shall invest and reinvest pursuant to the direction of the city and in the trustee's discretion in the absence of any direct instruction from the city. In other words, we can tell you how to invest if we wish.
One thing, what this deals with is money in the bond fund. The city pays 1/6 of the interest and 1/12 of the principal that's due from your tax collections on a monthly basis. Yes, you can tell the trustee how you want to invest within these limited parameters.
Okay.
There's not much there because the point of it is it needs to be extremely safe so the city doesn't have to come out of pocket because your investments lost a bunch of money. That's why it's CDs that are collateralized or under FDIC coverage or United States government securities.
Very good. Next page, 17. We're in section B, the last sentence of that one as well.
This section deals with the debt service reserve, which is basically the rainy day fund. In the event that the city can't make its debt service payments in any principal or interest payment, you have a reserve that is 1/2 of the maximum annual debt service on the bonds set aside in this account. And this section is talking about investing those monies.
In a secured manner.
It's the same thing. It would be in government securities and collateralized or FDIC covered certificates of deposits or what are called agency deposits, it would be something that's set up by the United States government, even though it's not necessarily guaranteed, but generally safe investments, so that the city doesn't have to come out of pocket to refill this fund because of investment losses.
Okay.
There's not going to be no stock market. There's no
Very good.
stocks or anything.
Okay, one last question, please.
Sure.
Page 19, section C. Section C, please, an explanation of that, if you will. Especially the very last line or two.
Okay, what this means is the federal government is allowing these bonds to be exempt from federal income taxation, meaning an investor will get interest on the bond and not have to pay income tax on that interest. The federal government puts this requirement in there because they don't want the city to issue tax-exempt bonds to completely subsidize a private business, giving the benefit of tax-exempt money to a for-profit business. So that's what this is saying, is that you are not using the facility. You can't build a building and then lease it directly to a company or something like that.
Okay.
So that it's called private business use, and that's what this paragraph is referring to. It's the city of Eureka Springs subsidizing a private company with the proceeds of tax-exempt bonds.
All right.
It has to deal with federal income tax law.
Okay. Very well. Thank you very much.
Any further? Okay, motion on the table to suspend the rules, and third reading by ballot title only.
Ms. Balance?
Yes.
Me?
Yes, sir.
Yes, I didn't hear you. You need to speak up a little bit.
Mr. Raphael?
Yes.
Ms. Lindblad?
Yes.
Mr. DeVito?
Yes.
It's an ordinance authorizing the issuance of sales and use tax refunding bonds for the purposes refinancing the cost of capital improvements, pledging 1% sales and use tax to pay the principal of and interest on the bonds, prescribing other matters relating thereto, and declaring an emergency.
Mr. DeVito.
Move to approve ordinance number 2153 on its third reading.
Second. Second.
Made and seconded?
Question, please.
Yes, ma'am.
Does this one bring into play the emergency clause, or will we be voting separately upon that? This includes that. This does not.
Should be separate, I believe.
The way it was read, it could be approving it. If you want to clarify that to do it separately, you can do that. But
I
you
would
need
ask
to.
that the city does it separately.
So we probably need to amend the motion that's on the table to authorize it without the emergency clause and then act on the emergency clause
So
separately.
Reseconded?
Resecond.
Okay. Thank you. This is an amendment. Do we have to do a roll call, or we're still?
You probably should do a roll call.
Please make this motion very clear. Would you repeat this, please?
To approve on the third reading less the emergency clause. Mr. Raphael?
Yes.
Mr. Berry?
Yes.
Ms. Balance?
Yes.
Mr. DeVito?
Yes.
Ms. Lindblad?
Yes.
5-0.
Should we?
I move to invoke the emergency clause.
Second.
Made
Probably
and
need to
seconded.
add the words suspend the rules.
Suspend the rules and invoke the emergency clause.
Second.
Made and seconded. Suspend the rules on emergency clause.
Mr. DeVito?
Yes.
Ms. Balance?
No.
Mr. Raphael?
Yes.
Ms. Lindblad?
No.
Mr. Berry?
Yes.
3 yeses, 2 nos.
7 enough. So I have to vote.
You would have to invoke your power.
Yes. Any further? Look everything you're gonna do? Mr. Bill?
Oh, I was going to move to adjourn.
Second.
Motion made and seconded to adjourn. All in favor, say aye.
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 Any opposed? Motion carried.